Greetings everyone, I'm Rahmah Candrika from the Law of Treaty class. I'm going to present the article that I'm going to review for the midterm exam of the Law of Treaty. The article that I'm going to review is an article by Panos Koutrakos called The Institutional Balance and Sincere Cooperation in Treaty Making under the European Union Law. So moving on to the background of the article, this article aims to identify the pragmatic streak on the procedures that govern treaty making by the European Union. As we know, the European Union is the supranational organization where the member states of the European Union give away a part of their sovereignty for this organization. The European Union is much more like a state where it consists of parliaments, councils, and other institutions that make them as a state-like organization. And this article also explores the principle of the institutional balance and the duty of cooperation between the EU institutions as crucial part in determining the treaty-making process in the European Union. In the treaty making process of the European Union, there's a so-called institutional balance on duty of cooperation, where it took a crucial part in determining how the European Union institutions are going to establish their treaty. In the end, this article argues that there is an inherent limit on primary law and constitutional law in the area of treaty-making process. What is actually important is the practice of the EU's institutions, such as the Council, the Commission, and the Parliament, that should reflect on how they can coexist and relate to each other. So before we go into the details of this presentation, I'm going to warn you that this presentation will only briefly explain about the critical review that I'm going to conduct. However, although these slides may be short in particular, I will explain more through this recording about how I'm going to conduct this critical review, and what are the essence of the article that I'm going to review. Next, this is the brief explanation of the principle of institutional balance and the duty of cooperation. So, institutional balance is a principle that implies that each of its institutions has to act in accordance with the powers conferred on it by treaties, in accordance with the division of powers. This principle also refers to the relationship between three main EU institutions, which are the European Parliament, the Council of European Union, and the European Commission. This principle relies on the basis of literal interpretation on their primary law or constitutional law, and it also promotes strict compliance with procedural dimension, and it does not favor a particular institution. However, the institutional balance is a well-known but elusive concept in the EU legal literature, meaning this principle is very hard to achieve because it is not mentioned and let alone defined in the treaties, but it was introduced by the court and in its case laws. A number of legal authors, even highly critical, added values of the notions and questions its status as the principle of the European Union law, and how will the EU institutions apply this principle. The function of the institutional balance is, of course, to give a clear implications of the authorities of the executive and the legislative implications within the EU institutions. However, it also parallels with the principle of separation of powers. That is why there is a elusive quality in regards to the institutional balance. Moving on to the duty of cooperation, as you can see, I made it as a comparison in this slide because I really want to distinguish the meaning and the essence of between these two principles. So the duty of cooperation is clearly stipulated Article 30 of the Treaty on the European Union. The principle of duty of cooperation allows each institution operates within its own treaty powers, procedures, and objectives and must cooperate with the others. The EU's various institutions must aim to promote the EU's values, advance the EU's objectives, serve the interests of the EU, the general public, and EU countries, and ensure the consistency, effectiveness, and continuity of EU policies and activities. Meaning that there must be a sincere cooperation in the treaty-making process, that the member states are indeed going to comply with the treaty based on their consent. Moving on, what is actually the issue here? So this article really is in the scope of between those two principles. The actual issue is the institutional balance is a well-known but elusive concept, as I have mentioned. It does give clear implications for the conduct of the institutions. However, it is not articulated in the treaties expressly. And this is further complicated by the fact that it is paralleled with the principle of separation of powers, and I'm going to explain on the next slide why this principle is further complicated. Moving on to the next slides, we can see that there is an Article 13, Sub-Article 2 that I have mentioned before on the Treaty on European Union that reflected the principle of institutional balance and also the principle of duty of cooperation. It is said that each institution shall act within the limits of the powers conferred on it in the treaties and in conformity with the procedures, conditions, and objectives set out in them. The institution shall practice mutual sincere cooperation. So as you can see, there is the addition of mutual sincere cooperation added at Lisbon Treaty. It provides a richer and more elaborate take on the principle. And this is the first time that the dimension of sincere cooperation is mentioned. The dimension of sincere cooperation is mentioned in primary law. Although the mutual duty of sincere cooperation between institutions has been recognized for some time, its explicit inclusion in the treaties in Article 13, Sub-Article 2 of the TEU, together with some changes to the institutional participation in decision-making introduced by the Lisbon Treaty, has led to an increased reliance on the principle. This addition of mutual sincere cooperation does not only formalize the application of the duty of cooperation into institutional interactions, but it also brings it together with the principle of institutional balance, meaning it further complicates the uncertainty of the principle of institutional balance. According to a European law professor, in regards to the institutional balance principle, as we can see that the institutional balance principle is only reflected on the Article 13 of Sub-Article 2 of the Treaty on the European Union. It is really not expressly stated that there is a principle called institutional balance in the EU law. So according to 3D Mas, European law professor, a principle must be judged on the basis of two parameters: the intrinsic value of the right that it embodies and how well it structures the judicial inquiry. These two parameters signify that if the institutional balance is to be a genuine principle of EU law, it should have a sufficiently clear content which guides the court and helps it in solving legal issues brought before it. The requirement of a sufficiently clear content should not be understood as a rejection of the traditional differentiation between a rule, which if applied automatically results in a solution, and a principle which underpins and justifies concrete rules, but does not in itself and automatically result in a solution to a given problem. As you can see, there is a elusive quality regarding the institutional balance principle, not only in the Article 13, sub-article 2 of the Treaty of European Union, but also according to legal scholars. Therefore, adding the sincere cooperation makes it more elusive. The hand-in-hand approach of the institutional balance principle with the duty of cooperation principle makes it more difficult for the member states to apply. And moving on to the duty of cooperation principle, there is also a elusive quality towards the duty of cooperation principle, because after a brief analysis of the treaty framework, the question is whether the duty of sincere cooperation involves a duty of result or rather a duty of conduct for the member states. So it is hard to measure on where the principles would apply. So it is very hard to achieve. Continuing the two principles that are being reflected in Article 13, sub-article 2 of the Treaty on European Union. Therefore, in order to be consistent with the constitutional character of the EU legal order, the EU decided that the implementation of the principle of institutional balance requires compliance with the duty of cooperation. And exploring these two principles as themes from my article in the context of treaty making will shed a light on not only how the EU's decision-making actors relate to each other, but also the role of the Court of Justice. As in these articles, there are a lot of judges who give their opinions towards case studies that are related with the principles of the EU in the treaty-making process. So moving on, the questions for the critical review that I'm going to answer later on in the critical review is what the EU does as a treaty-making actor, how the EU does as a treaty-making actor, how the EU and or member states may act in the process of treaty making, and lastly, at what point does their duty to cooperate end and where does it begin to amount to an infringement of other institutions' prerogatives. And here are the plans for the critical review, where in order to make the critical review, I would address the elusive quality between these two principles. I plan to firstly explore how the EU negotiating its international treaties. Secondly, explore the procedural dimension of the EU Parliament, especially on their right to be informed. Thirdly, focusing on how the principle of institutional balance and the duty of cooperation play out in the context of treaty making. And lastly, the elusive quality of both principles as reflected in case studies. So, regardless of the plan that I made for the critical review, according to my research on this, I wanted to conclude that that the elusive quality is not the issue here, and it should be resolved by the practice of the EU's institutions, because the practice of the EU institutions itself are what really define the elusive quality of these two principles. And it is the council, the commission, and the parliament that should reflect on how do they related to each other. And furthermore, I want to conclude that they should take a leap. By they, I mean by the EU institutions should take a leap of faith, where the principle where they can take the institutional balance principle seriously, and approach the duty of cooperation principle in the EU treaty making conduct in a constructive spirit, because the last time because the less time and energy they waste on establishing their procedural powers, the greater their contribution to increasing the efficiency of the union's treaty making practice.